about 30 seconds. Thank you all for joining. My name is Ahmed Torre, and I'm here on behalf of Torre Legal. And today we're just talking about estate planning for parents, essentially, right? So if you have any children, minors, this is the workshop for you. Today we'll be covering. Can you all see that? Get the screen right. Okay. You won't be able to see me as much, but that's fine because it's about the presentation. That's what really matters here. So thank you all for joining us. It's 8:30 on a Thursday, and there are plenty of places that you could be, but you all decided to be here to plan for your family, and that's very commendable, and I want to make sure that I make great use of your time. So today we're talking about the family playbook, and essentially it's about making decisions while you can that will outlast you, right? Decisions that'll keep your family together, decisions that'll keep people from fighting, decisions that'll make sure that your wishes are always carried out. All right, so here we go. Let's get this thing started. All right, so first and foremost, can you all see that? All right, so first and foremost, life is really about decisions. And today we're focusing on just 3 decisions, all right? Your healthcare decisions, your financial decisions, and guardianship decisions. So what does that look like? Well, healthcare decisions, that's pretty simple. It's what happens if you're incapacitated, right? What happens if you can't speak for yourself? Do you want them to keep you on support? Do you want someone else to make decisions on your behalf? Do they have access to all the documents that they need to make the proper decisions on your behalf? Those are your healthcare decisions. Financial decisions are sort of similar. So if you're incapacitated, you still have bills to pay, right? If you're incapacitated, you don't get to say, hey, I'm in a hospital, I have a coma, and so I shouldn't have to pay the Netflix bill this month, right? It doesn't work like that. Unfortunately, these businesses still want their coins. And so what you have to do is make sure that you put a plan in place so that if you can't make any financial decisions, someone can step in on your behalf to make those decisions. We often think that our spouses are superhuman, right? And they have all this power, and they could step in for us, and they can access our bank accounts, and they can talk to our bill collectors, and it simply does not work like that. So we're going to talk about what to do to make sure that your financial decisions can still be carried out, even if you aren't there to carry those decisions out. And then the last piece is just about guardianship, right? For those of us with young kids, I know quite a few of you on here have quite a few young kids. Myself, I have two beautiful young kids. And so we have to make decisions around them as well, because unfortunately, we don't know how long we'll be here, but we want to make sure that we put a plan in place so that their lives aren't ruined at the end of our lives. Okay? All right, so let's start this party. All right. And also, if you have any questions or anything, just put them in the chat and I will answer them. I should have about 5 to 10 minutes at the end to answer your questions. All right, so first and foremost, so what happens if you don't have a plan? I think this is the easiest way to start this conversation, is what happens if you do not have a plan? There's a story about this lady named Terri Schiavo. I don't know if you remember her. For all my millennials on here, Terri Schiavo, that story happened in the 90s, I believe. And what happened was, Terri Schiavo was a perfectly healthy young lady. She was married. And as she was going on through life, she just all of a sudden slipped into a coma. All right. She was told, her doctors told her loved ones, her husband and her parents, that she would be in a vegetative state. She would have to be hooked up to this machine. So her husband said, she wouldn't want to be hooked to a machine, so let's pull the plug. That's what the husband said. Her parents said, no, we want her to keep fighting. So keep her hooked onto the machine. Obviously, there's a conflict there, right? What the parents want and what the spouse wants. And because she didn't make any of these healthcare decisions on her own beforehand, then it left it to everyone else to argue on her behalf. So what happened? Well, it took 15 years. Lawsuits after lawsuits after lawsuits from the spouse and from her parents that prevented anyone from making any decisions about pulling the plug. And the Supreme Court eventually ruled on what could be done. But it took about 15 years, and it also took millions of dollars. But more important than anything is it severed the relationship between those family members, right? The in-laws and the son aren't rocking anymore because they have a disagreement about what to do about Terri Schiavo's care. Now, it seems like, that wouldn't happen to me, but I can assure you that you know someone who's been affected by healthcare decisions having to be made, or you know families that have been torn apart by healthcare decisions that have to be made. And so what we want to do is make sure that we don't leave our family members or our loved ones in a terrible situation of having to decide what to do with our life. We want to make those decisions on our own. Now, for our healthcare decisions, I'm going to go ahead and give you some of this free game. For our healthcare decisions, there's a thing called a living will. All right, it's a healthcare directive. Every state has its own healthcare directive. And what you do is you fill out this particular form, right? It's your healthcare directive. You fill out this form and you say, hey, if I'm on, tubes, I want you to pull the plug. Or if it reaches this amount of point, I want you to pull the plug. Or no, I want you to keep me on until X, Y, and Z. You get to decide as much as you possibly can before or, in the event that you ever get put into that situation. Now, let's be clear. You're probably not going to end up in that situation, right? You're probably not going to end up in a situation where you're in a coma and someone has to make a decision for you. You're probably not. But in the rare chance that you are put into that situation or someone you know is put into that situation, it'd be great if they would have left us some directions beforehand so that we know how to decide on their behalf. And that's what a living will and the healthcare directives do. They make sure that people know what your medical wishes are so that there is no bickering amongst family members about what happens. Okay? That makes sense. The next thing that you have to do, so you have your living will, right? You have your healthcare directives, and these things could be found at hospitals. They could be found on your state. If you just Google living will for North Carolina or living will for Georgia or healthcare directive for Georgia, you'll find these forms and you can fill out these forms. Now, a key thing about these forms is you have to get it executed properly, meaning you have to sign the form. There has to be a witness there that sees you sign the form, and it has to be notarized. That makes it completely official so that if it needs to be used, it's ready to be used, okay? And that prevents you from having, or your family members from having to fight over what does mommy want or what does daddy want, right? We don't want to have to deal with that. We want you to make those decisions as best as you possibly can to prevent them from having to make those decisions. All right. Another healthcare form that you need, and I will send you all a resource guide. Okay. You will receive a resource guide. The resource guide will have all the information in it. But in case you want to jot down notes, here's the second thing that you will need. You will need HIPAA authorizations. HIPAA. Okay. HIPAA authorizations. The reason we need HIPAA authorizations is so that people don't have to make decisions about your health on a whim. Right? We don't want them to rush it. So the person that you designate to make healthcare decisions on your behalf, you want to make sure they also have HIPAA authorizations so that they can discuss your medical history with your doctors. Without that, they may have to go to court. I'm seeing the questions. I will get to the questions towards the end, but I appreciate you. Keep pouring those questions in. Without a HIPAA authorization, they may have to go to a court, go to a judge to get someone to give you the permission to look at that paperwork. So to prevent all that from happening, because life could be hanging on a balance, right? And we don't want someone to have to go to a lawyer, then a doctor to get these authorizations. We want to make sure that you give it to them so that they can save that time and they can make life-saving decisions if necessary. So HIPAA authorizations are also very important. All right. So for medical decisions, I'll recap really quick. For medical decisions, we don't want to end up like Terri Schiavo, where our family is fighting over who makes what decision. We want to make those decisions in advance, and that's what we do with our healthcare directive. Now, of course, you can get a lawyer to help you with that, but you can also do it yourself, okay? Free game, okay? You can just look up healthcare directives for your state, and you'll see the template. You can fill it out, make sure it's executed properly. If you have any questions about that, I'll surely help you with that. Okay. The next situation. The next situation. Now, we all know Britney Spears, right? We all know Britney Spears. Britney Spears, very popular individual. She's someone who was affected by not having the proper power of attorney forms signed beforehand. All right. So why does that matter? So let's give an example. Jack and Jill. All right, I'm gonna give you a big picture, then we'll go to Britney Spears, and then we'll take it back to us, right? Jack and Jill are married. Jill falls down the hill and ends up in a coma. Now, Jill was the breadwinner of the household. So Jill was paying the mortgage. She was paying the bulk of all the expenses. Well, once Jill ended up in that coma, she didn't have but so many paychecks for people to pull on, right? And so what happens is we need someone to access maybe her savings account to put the money from the savings into the checkings so that bills continue to be paid. Now, a lot of people think that if you're married to someone and you're incapacitated, that your partner has the power to go to the bank and say, hey, this is my partner, give me access to their accounts. It does not work like that. You have to get a power of attorney beforehand. Without that, your financial assets will be frozen. And trust me, that is a very lengthy process. Just for example, we all know Chadwick Boseman, okay? R.I.P. Chadwick Boseman. He was married. Once he passed away, his assets became frozen. When his assets were frozen, his wife had to pay for the funeral out of her pocket, had to pay for expenses out of her pocket. It took a year and a half for the courts to grant her the power to get access to those accounts. Now, could you imagine if your partner, the breadwinner, was in a coma or incapacitated or just not around, and they couldn't contribute to the expenses as was part of their plan, and then you have to carry those expenses on your own for a year and a half? Could you imagine the stress that might cause? In addition to grieving, now you're also having to deal with this red tape situation with these finances. And how do we deal with their finances, right? So we want to make sure that we have power of attorney forms. Now, power of attorney forms, there are multiple types. There's one called the durable power of attorney that's relevant for our conversation, and there's a healthcare power of attorney that's also relevant for our conversation. The healthcare power of attorney is for allowing people to make healthcare decisions on your behalf. So you designate your power of attorney for healthcare decisions, and that person has the authorization to make decisions on your behalf. Okay? That's a healthcare power of attorney. It has to be executed beforehand, meaning it has to be signed, preferably by a notary. So you have to sign it and then give it to a notary so the notary can notarize it, so it becomes an official document that the courts and the hospitals can follow. So that's your healthcare power of attorney. Another power of attorney, and this is for those financial pieces, is a durable power of attorney. Now, this is in the event that Jack and Jill are together and Jack is unable to make decisions on his behalf. Jill can step in as a financial power of attorney to access Jack's accounts to make sure that bills are paid and that money is moved around appropriately. Because if Jack is in a coma for 3 months or 4 months, the issue is, come on, TV. If Jack is in a coma for 3 months, the issue becomes, how does Jack's bills get paid, right? Or should Jack still be paying for this gym membership if Jack is in a coma? Well, the wonderful thing is, if Jill has the power of attorney, Jill can step in and say, hey, look, Jack is not available at the time. We're going to pause these subscriptions. We're going to pause these bills. We're going to move this money around. We're going to invest it because Jack isn't working at this time. And so we want to make sure that we're doing the best that we can with that person's resources, right? So that's your durable power of attorney. The wonderful thing about durable power of attorneys is that it can be limited to just emergency situations, right? So you don't have to worry that if you give somebody a power of attorney that they go on and start making a whole bunch of decisions even while you're alive behind your back or while you're present behind your back, right? We don't want that. So we want to limit the power of attorney just to situations in which you are incapacitated, okay? Wonderful, wonderful. Now with the Britney Spears situation is a little different, but not so much. Britney Spears had all these assets, and she was put into a mental health institution. And so while she was there, she could not access these assets. She had bills that still had to be paid, mortgages, notes, all these things. And so what her family did was they went to the judge and said, hey, judge, we need a conservatorship. The judge granted the conservatorship, and that gave them access to her father access to manage those funds on her behalf. Now, we remember the issue with that, right? The issue became, well, is he doing it with her wishes? Is he doing what she would have wanted and this and that? The problem is she didn't have a durable power of attorney already set up. So she couldn't already decide, hey, if something happens to me, here's who I want to handle my resources, right? And handle my financial responsibilities. So that was the situation with the Britney Spears case, okay? So those are the financial implications. And then lastly, our kids. With our kids, without... Not yet, Z. Can you go up? Sorry, that's my kid. Take it easy, Z. So with our kids, we have to make sure that we designate who we want to be the guardian of our children. And this is something that has to be done in a will, okay? You can't make a guardianship designation over text. You can't just make a guardianship designation just willy-nilly. I know Sienna had just mentioned something about like in-law having like a godparents and stuff. And, sorry, y'all. Godparents don't count for guardianship. Stop, sorry. All right, guardianship doesn't count for those sorts of purposes. All right, godparents don't count for those sorts of purposes. So we have to make sure we designate someone to be a guardian of our kids, and that has to be done in a will. The reason why it has to be done in a will is because it has to be taken to the court, and the court has to authorize it, right? So the court's going to look at who did you designate to be the guardian, and they're going to make sure that no one has any objections with that or there aren't any issues, right? God forbid someone made the guardian of their kid R. Kelly 20 years ago, right? Today, the judge might have an issue with that. So you go to court and it has to be approved, right? And it has to be put in a will. Now, another thing about our children, and I'm going to change slides here in a second. Another thing about our children is that you have to be very thorough. Yeah, Kelly has got first. You have to be very thorough about who you decide to be the guardian of your kids, because that comes with financial responsibilities, right? And then also there may be decisions that you want them to follow, right? Your intentions, your wishes that you want your kids to follow. And so it's more than just appointing a guardian, right? It's also giving the guardian instructions. Like, I want them to practice this type of faith, or I want them to go to this type of school, or here's the funding for them, and X, Y, and Z, right? So we have to make sure that we are very intentional about who we want to be the guardian of our kids. We want to have that conversation with them. We want them to accept it, and we want them to know what our standards and our values are that we'd hope that they carry on for our children, okay? All right. Okay. I say all that to say, the Family Foundation Plan is a comprehensive way that we put all this together for you, all right? So we'll put your power of attorney together. We'll put your HIPAA forms together. We'll make sure your healthcare directives are intact. We'll make sure that there's a will that designates the guardian. And we'll also make sure that the will doesn't just give your kids a lump sum of cash at 18, right? Because I think we all know that the person that we were at 18 is not the person that we are at 25 or 27 or 35 or whatever the age may be. And so the last thing we want to do is give an 18-year-old a lump sum of money. Unfortunately, that's what wills do, right? If you have a will without a trust provision, then at 18, the kid gets the money as a lump sum and, prayers that all goes well, right? But if you want, you can put a provision that creates a trust just for that minor. So it says, hey, they'll receive a lump sum at 18, another lump sum at 25, another lump sum at 30. And the positive thing about that is that between 18, 25, and 30, the amount that's in that trust will continue to grow, right? It'll grow because there's a trustee who manages those resources, and they'll make sure it grows so that when he turns 25, they can get more. When he turns 30, it can get more, right? And you can put whatever decisions you want on that trust. You can say, I want them to receive an allowance, and I want them to receive extra money for housing, tuition, education, yada, yada, yada. But anything outside of that, they have to use their allowance. You can put that in the trust. You can put all the instructions in the trust that you want. Some people even got in trouble because they said things like, I only want my daughter to marry this particular type of person, this particular type of race. And the daughter had an issue with that, so she took it to court, and it became invalidated, but she lost a lot of money in that process, right? So just make sure that your provisions and your trust and your instructions for your kid are meant to help them grow and not meant to hold them back. All right, and with the family foundation plan, those sorts of things are included. All right, and that's the wrong button. All right, so let's just give the example. Okay, let's just give the example. Everyone remembers the movie Soul Food, right? Soul Food, wonderful movie. Big Mama's there. We at her house. We're having meals on Sunday. Big Mama, she starts having her health conditions. She starts having these issues with her own life. And then the sisters or her daughters have to come in and they have to step in and do what mom would want, right? Do what mom would want. Now, in that situation, there wasn't a plan. And so they had to figure it out on their own. Now, fortunately, they're resilient, so they were able to figure it out. And it is a movie, so you got to make sure it works out. But in real life, it doesn't work out that way. I've seen plenty of families torn apart because the daughter wanted this decision to be made, but the mother made this decision. So now daughter and mom don't get along. Or the parents pass away and the siblings inherit the property, and then the siblings say, mom would have wanted it to go this way, or mom would have wanted it to go that way. And they start bickering. And then they start selling the property. They start selling their shares of the property. And now this thing that was supposed to be held on for generations to generation to prop up particular communities is no longer there because there wasn't a plan in place. Now, let's contrast that with a family that has a plan. All right, let's look at the Rockefellers. All right, you may not know too much about the Rockefellers, but here's the thing that's really impressive about the Rockefellers. All right, the Rockefellers started their trust in like the 1913 era, right? So early 1900s. And the beneficiaries of that trust still have billions of dollars of assets to manage today because of their trust. Okay? Billions of dollars of assets today because there was a plan in place. Now, another example is Muhammad Ali. Muhammad Ali, as we all remember, towards the tail end of his life, he dealt with Parkinson's, right? He was dealing with some cognitive difficulties. And so he had a healthcare directive in place. He had a plan in place that allowed him to live life on his terms till the very end. All right, those are wonderful examples of people who have had plans, and those plans were carried out, and it worked out for their benefit, as opposed to situations where there weren't plans, and people are fighting over, well, who does this and who does that. I know you all heard about the Prince estate. Prince estate is still going through it. Because there wasn't a plan there, and people are fighting over what to do now, what to do now. So it's a really sad situation. I was even real random story. I was in court once, and I don't know if you all recall Kalief Browder, but Kalief Browder's situation. He was wrongly incarcerated. He got out of jail after about 2 or 3 years, and then eventually he lost his life shortly after his release from prison. And so I was in court in Bronx. It was in the Bronx surrogate court, and Kalief Browder's father was in the courtroom asking for some of his estate. And the people from Kalief's mother's side were really upset about the situation because they felt that he hadn't contributed anything and yada, 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 yada. And so that became an issue. And so they were fighting about it because there wasn't a plan. I bring that up to say it's also never too early to have your own plan, okay? So pretty much what we're trying to avoid here, I said a lot, but what we're trying to avoid are our family members fighting when they should be grieving, when they should be coming together. It's hard for us to prosper as a community if after every generation we're dealing with fighting over resources and splintering of what's supposed to be a strong family unit. If there isn't a strong family unit, then it's hard for us to come together as a family or as a community to make sure that we continue to prosper. And so that's why we need to have these planning meetings, because a lot of people think planning is just for rich people. Planning is for people who want to make sure that their legacies live on and their families continue to grow strong. All right. So you're never too young to plan, right? You can have an estate plan as early as 15, 16, 19, 17, 18. You can have an estate plan really, really early in life, which is recommended because things happen, right? There is no age limit for catastrophic events. Not enough assets. As we mentioned, nothing in here in this conversation is about money, except for the financial power of attorney. But it's about people making decisions on our behalf. Healthcare decisions, financial decisions, decisions with our children. Family knows my wishes. That's a common myth. Your family doesn't know your wishes, okay? And your wishes may have changed over time. So what your mom might have heard 10 years ago and what your sister might have heard 5 years ago could be completely different. They were both your wishes, but which wish wins the day? We don't know, right? So we don't want to leave it up to our family. And then people think planning is costly. As I mentioned, you can get these healthcare directives for cheap. You can get them for free, actually. You can actually write your own will as well, right? You can write your own will, get it notarized, and put your guardianship provisions in there. You don't have to pay an attorney to do that. What the attorney will do is give you the bells and whistles, right? So hey, you should do it this way, right? Because these issues tend to arise, and X, Y, and Z. All right. So how it works, I know I said a lot. I'm going to open it up for questions. How it works, really simple. We have a strategy session. We talk. We have a consultation about what your particular situation is, right? Children, spouses, accounts. Who do you want to handle things? Who do you want to make decisions? X, Y, and Z. After that, you receive your family foundation plan, which has your power of attorneys. It has the will in there. It has the HIPAA authorizations. It has everything that is needed so that life doesn't get upended for everyone else because it became a little catastrophic for you at the moment, okay? And then after that, it's a signing. It's a whole celebration, right? You have this signing celebration because you're doing a wonderful thing to protect the legacy of your own and make sure that your family continues to move on strong, all right? I keep pressing the wrong button. All right, we just said that, okay? Conversation, we design it, and then the signing and storage so that it's available when it's needed. All right. So that's it, all right? It's a plan for peace. We're making sure that our family members know our wishes so that if something catastrophic happens to us, they can just focus on the emotional part, right? On caring, on grieving, on trying to help out, as opposed to trying to fight other family members about what decisions to make or who gets the kids or how are we going to pay for these bills, right? These aren't things that we should be having to deal with when we're already dealing with catastrophic events, right? The last thing you want to deal with at the hospital is figuring out who's going to pay what, who's going to pay this. All right, so let me get to some of these questions. Okay, great. All right, thank you all. Great. Does a living will trump a POA in the USA? So that's a really, really good question. Does a living will trump a power of attorney in the USA? So, no, it does not, right? So the power of attorney is who you designate to make certain decisions on your behalf, right? Who to act on your behalf. So that's what the power of attorney does. What the living will does is it lets the doctors know what your decisions are. So your decisions, yes, it does trump the POA. Your decisions will be taken into consideration first because that is your living will. The power of attorney for healthcare decisions comes in when there's a gap somewhere, right? So maybe you planned for comas and being incapacitated and X, Y, and Z, but maybe you didn't plan for if you lost your mind because all of a sudden dementia kicked in, right? And so a POA might step in that situation and say, okay, I'm the one that makes these healthcare decisions, and here's the decision I make, all right? So it will not trump, the POA does not trump the living will. The living will is your decision. It's what you want to be carried out on your behalf. And so unless there's a provision that you haven't really answered for, we're not going to the power of attorney for healthcare stuff, okay? Yes, having your own plan is absolutely important, right? You want to have your own plan. We've seen a lot of fighting that could have been avoided without a will or trust. What do you suggest is the best way to start the conversation with family about these issues? Yeah, so this is a tough one because family members don't want to talk about their own death, right? Nobody wants to talk about that. And then there's also some of that mistrust. And it's not because of who the person is asking the question. It's just that there's a history of mistrusting banks and organizations, especially financial structures in this country, right? Rightfully so. At one point we were all putting our money in banks, and then the banks failed, and miraculously only our money got taken, right? And so I can certainly understand why people would be a little more hesitant to have these sorts of discussions. But the best way to do it is to talk about the decisions, okay? In the event that something happens, right, what do you want to happen, right? You can be even jokey about it, right? You can say, look, if you went to sleep in the Bugatti, okay, you went to sleep in the Bugatti and you're dreaming and they say, hey, sleep time is almost over, but FYI, your Bugatti is no longer Bugatti, you're now going to be in a Pinto for the rest of your life and you can't upgrade. Would you want us to bring you back, right? So maybe have jokey conversations like that. But you want to have these conversations, and if you could, just frame it around the decisions, okay? Who do you want to decide for this in your behalf? Would you want to be brought back if you were in a vegetative state? Would you want to be brought back if you had to stay hooked up to machines your entire life, right? Have these sorts of conversations, okay? So that's a good way to frame it is, how do you want these decisions to be carried out when you're not around to make these decisions, okay? And if you could, make it about like someone else, right? So don't go to your parents and say, hey, mom, when you die, what do you want to happen, right? You don't say that. You say, hey, mom, I just saw this Prince situation and it was kind of crazy. And I was wondering, like, what you think should have happened in that situation, right? So now y'all are having a conversation about the particular issue without dealing with your own mortality, all right? Let's see. I hope that helps. Cost. So the Family Foundation Plan, it comes with a lot. So this one is going to cost, it's going to be like $975. There may be some add-ons that we can put on there. Of course, payment plans are accepted and everything like that. But the value that you're getting is wonderful because you're getting a will, you're getting provisions for guardianship, you're getting all your power of attorney forms, you're getting all your healthcare directives, and then you're also giving a way to transfer it into a trust later on, right? So if you purchase a home later on and you want to make sure you update your will to include that sort of provision, we can do that for you, right? So it is close to around $1,000 to get this thing done, but it's absolutely worth it because now you get the peace of mind. You get the peace of mind knowing that, hey, if something happens to me, my family's not going to fall apart. They're going to grieve about it, but that's it. And not to even be funny about it, but you also know that your family won't have to do a GoFundMe on your behalf because not that you didn't have any assets or your family doesn't have the assets or the resources, but it's just that maybe all the money was in your account. You were the breadwinner, and now you're no longer around to manage that account. And so we have to go through the courts and probate, and that takes a very, very long time. And so this way you can rest assured knowing that your healthcare decisions will be adhered to, your kids will be taken care of the way you like for your kids to be taken care of, and your financial responsibilities will be carried on in the event that you're incapacitated. All right, let's see. I went through hell when my mom was hit, and yeah, right, because you just never know. Life happens really, really fast, and so we want to make sure things are put in place before life happens because life be life. What happens if the person you designate dies before you? That's a great question, right? So with the Family Foundation Plan, you do get yearly reviews, right? So you get updates. So if something happens, you can have a conversation. We'll have a yearly conversation. You say, all right, so-and-so is no longer around or I'm not with this person anymore, so I want to update it. And that's how we update it. Now, a lot of times there is, like in our provisions, there are your main, like the person that you want to designate initially, and then there's like a secondary designation. So someone who steps up in the event that your primary designated person just is unavailable to carry on these responsibilities. All right, so yeah, that's a good question. So to answer your question straight up, if the person you designate dies before you, then hopefully you'll get an opportunity to update it. If not, hopefully there was a secondary person placed in there. If not, then we'll have to go to the court, unfortunately, and that's what we want to avoid. Okay. Does every state recognize handwritten wills not filed by an attorney? That's a great question. I know most states. I can say that with absolute confidence. Maybe a state decides we're not doing those sorts of wills anymore, but I doubt it, right? Because people are often allowed to write wills on their deathbeds, right? It just needs to be someone who's there, who's a witness, and who can sign it because you can do handwritten wills. So, yes, it will be recognized by most states. More than likely will be recognized in your state. I know in Georgia it will be recognized, but just double check for your particular state. Okay. But for the most part, yes. The most important part with handwritten wills is just making sure that it's executed, right? So it has to be signed by you in the presence of a witness that's not a beneficiary under the will, and then preferably getting it notarized as well so that we know it's official tissue and there's no questions about it at court. Question, is a trust inclusive of the 975 or is that an additional cost? So if it's a trust for your children, right? So if you have a provision, you say, hey, look, I got a 4-year-old, a 5-year-old, and I want to make sure that if something happens to me that they're taken care of, what we'll do is we will create a trust for that child, right? So that will be included in that 975, all right? Also, if your child has special needs, right, that will also be included in that 975 to make sure that everything, like, because special needs kids they need their own trust, right? Because people has to care, it has to be an ongoing caring of them. It's not just a lump sum thing. So that will also be included in there. All right. Let's see. You have a partnership with life insurance brokers. How do you incorporate life insurance within your will? That's a great question. So, yes, I do partner with life insurance brokers. I have a good friend named Art Sherrod. He works for Principal and he does a lot of wonderful things. And we are going to have another conversation in a few weeks about incorporating life insurance with these estate planning devices. Now, life insurance and a will doesn't necessarily work hand in hand because the will isn't a thing that you can put life insurance into, right? A trust is something. Like a trust is something, right? Typically, there's a trustee managing it. So if you can have your life insurance, you can designate the beneficiary of your life insurance to be your trust, right? And that's what a lot of people do. That's what the Rockefeller family does. If y'all don't mind, let me just share for a second. Here's what the Rockefeller family does, and I think it's brilliant. As soon as someone is born, they get life insurance, all right? As soon as they're born, they get life insurance, like $1 million policy or something, all right? The beneficiary of everyone's family life insurance is the family trust, okay? So when someone passes away, the $1 million or whatever the policy number was comes back into the trust. Right, so we're making sure that for generation to generation to generation, like we continue to advance, right? We can continue to advance. Now, another benefit of that is when you have all those funds in the trust, it acts like a bank, right? And so you're 18, you can go to the trust and get a $100,000 loan. And of course, the trust will give you the funds because they know that you have $1 million policy, right? They know that you're going to recoup it. The trust will recoup this loan at the end of your life, right? And so those are wonderful. We discussed that a little later in some of our more advanced estate planning situations. But long story short, to answer your question, the will isn't a great place for a life insurance because what will end up happening if it does work, it will go to your estate and then it still has to be divvied out to your estate. So if you have it in your estate and you haven't like provisions for like pour overs, like if there's something in my estate that I haven't designated to go to someone, and here's the pour over provision, and so it goes like that. So you can do that, but I wouldn't recommend doing that because you still have to go through probate. It would be best to go through a trust so that those funds would be immediately accessible. If you have to go through probate, then we have to find someone to be the executor of your estate. They have to be appointed, and you go through a whole court process. And just for case in point, Chadwick Boseman's estate took over a year to get settled, right? So all those assets were frozen for a year. And so to prevent people from having to do GoFundMes until the assets become free, it's best to put it into a trust. Yeah, that would be a great book. Pre-dated time, joint revocable trust, rental properties. Yup. Okay, all right. So this is a little more advanced, but I will talk about it, right? Irrevocable trust versus irrevocable trust. Now, if you are going to have a conversation with your parents, this is a wonderful conversation to have with your parents. They say, hey, mom, dad, I know you all are approaching the sunset years, right? The golden years of your life where you want to retire and just kind of ride off into the sunset. Well, check me out, parents. You do know that in the event that something happens to you, you won't necessarily get all Medicare like that, right? You won't get Medicare just all willy-nilly because what tends to happen is the hospital sees you have all these assets, like you have a house, you got this in your account, you got these cars, and you're asking for Medicare. What tends to happen is Medicare says, hey, look, I need you to spend that. I need you to go sell your house first, and then we'll come give you the money for this major expense, right? Oh wow, that is actually a book. All right, so hold on, kids are having a temper tantrum. All right, so yeah, but so someone who's approaching retirement, you would say, look, get an irrevocable trust, put all your things into an irrevocable trust, because then that means it's not yours, right? It's not yours on paper. No one has it. No one can see it. What that does is it shows Medicare that you don't have anything, and then Medicare will start giving you funds. The trick to that is the IRS has this thing called a 5-year look-back provision, right? And so what that means is after 5 years, that's when we can say that your things in the irrevocable trust are no longer yours. All right, so that's a wonderful time to have an irrevocable trust. When you're trying to plan, when you're trying to pass on assets or make it look like you don't have anything, that's a great thing for an irrevocable trust. With respect to a revocable trust, that's good because you still have control, right? So a revocable trust is really just a vehicle for you to put all your other things into, right? So you can see everything you have and you can manage everything you have right there from that trust. All right, man. All right, so that's it. Does anyone else have any other questions? Okay, great. Look, I appreciate you all. We went a little longer than I expected, but I really, really appreciate you all for joining. I will send everyone on here a resource guide, so you will get that information, so you can have these sort of conversations, all right? Thank you all for your time. I truly, truly appreciate you. Have a wonderful day. Thank you all. Be well. Thanks, y'all. I really appreciate this. Really, I really do. No, thank you. Thank you all. Thank you all. All right. Let's end this part. I'm sticking around, but you don't gotta go home. Okay, you don't have to go home, but you can't hang out on the Zoom. Okay, you can't hang out on the Zoom. All right, man. I appreciate you all. Be well. See ya. Great. Whew. Oh.